So now we can move to the topic of breach. And what is breach? It is simply failure without legal reason, okay, to comply with the performance of the obligation, okay? Now, what is the general remedy for breach? In general, damages are the remedy for breach. And as I explained in my previous video, damages are different from damage. Damage without the S is simply the physical injury or harm which is suffered, while damages are the monetary or pecuniary compensation for the harm or injury which was suffered. Okay? Again, to be clear, damages pera. Okay? Okay. And damage, yun yung sira. Okay? Okay. Now, the rule on damages is, the purpose of damages, why they are awarded, is to place the innocent party in the same position, not better, in the same position he would have been had the obligation been performed according to its terms. Okay? Damages does not seek to place the innocent party in a better position, only to restore him to his position had the obligation been performed according to its terms. Okay? So the law provides that damages are available in case of breach when it is attended either by default, fraud, negligence, or contravention of the tenor of the obligation. Okay? Just remember those, DF and C. Now, we can first talk about default. Okay? Default is otherwise known as delay. Okay? But the proper term is default. Why? Because delay can simply mean failure to perform an obligation on time. And that is just ordinary delay, okay? Whereas legal delay or default constitutes breach of the obligation, okay? In other words, in order for there to be default, first, there must be a obligation which is demandable or liquidated. Second, there is a failure to perform at the prescribed time. Third, there is a demand. Okay, there is a demand by the creditor for performance. And after the demand, there is failure to perform the obligation. Okay, demand is, sa general rule, essential. Okay, it is necessary to constitute the debtor in default. Without such demand, there can be no default. Okay, but that is merely the general rule. Okay, first, let's talk about unilateral obligations, meaning only one party to the obligation has the duty to perform. Okay, in case of unilateral obligation, if there is no demand, then there is no default or delay. Okay, except if the parties have stipulated, if the law so provides, if time is of the essence of the obligation, or if demand would be useless. Okay? And in case of reciprocal obligations which require simultaneous performance by the parties, meaning when one party gives something or performs his obligation, the other party must also perform his obligation. Those are reciprocal obligations, okay? There is default in reciprocal obligations when one party is ready to comply with his part and the other is not. Then delay begins. Okay? Delay on the party who is not able to perform his obligation begins. Okay? However, there is an exception in case of reciprocal obligations. What if different dates for performance are imposed upon each party? Like, let's say this party is supposed to perform it on August 15th and this party on November 10. Okay? Default will only happen after the dates have expired. Okay? Okay. Now, let's go to the kinds of default. First, we have mora solvendi. Okay? Mora solvendi simply refers to delay or default on the part of the debtor. Okay? This does not apply in obligations not to do. Okay? There can be no default in negative personal obligations. Okay? So this involves the positive acts, either to do or to give. Okay? Now, I said this is default on the part of the debtor. So what are the effects once we know that the debtor is in default? How does the debtor become in default again? There must be a demand on the part of the creditor and the debtor fails to heed the demand, okay, or fails to perform after the demand. Okay? So what are the effects of mora solvendi or delay of the debtor? First, of course, the debtor will now be guilty of having breached the obligation. Second, the debtor will now be liable for interest and or damages counted from the date of default, no, after the demand. Okay? Next, the debtor is liable in case the thing is lost or destroyed due to a fortuitous event. Okay? Because the debtor should have performed this obligation on time, but since he did not, then the thing was lost. He is held liable even if the thing is lost due to a fortuitous event. Okay? However, that applies only in case of a determinate thing. Why? It does not apply in case of a generic thing, because in case a generic thing is lost, even due to a fortuitous event, the obligation is not extinguished. Why? Because genus non quam peruit. Genus never perishes. The debtor can always get the same thing of the same kind and same quality to perform his obligation. If you remember my example, if the obligation was to deliver a white Westinghouse refrigerator without specifying the motor number, etc., then he can just get another white Westinghouse refrigerator. The rule is different if the thing that was lost is determinate with motor number. In that case, if the debtor is in delay, then he will be liable for the loss of the thing. Okay? Now, I mentioned earlier that demand may not be necessary in order to constitute the debtor in default. And when is demand not necessary for the debtor to be in default? Okay? The law gives us certain instances, no? First of which is when the parties so stipulate. An example is when the obligation is entered into with the words without need of prior demand. Okay? Pay me 5,000 pesos on within 30 days without need of prior demand. Okay? Next is when the law itself requires a time for performance, such as the payment of taxes. No, the law itself gives us the date on when we should pay our taxes. So demand is not necessary to render a debtor liable, okay, for payment of taxes. Next, when time is of the essence, no? When the obligation was entered into stipulating that I need this by a certain date, okay, such as I need a wedding dress for my wedding on May 15, no? In that case, time is of the essence and demand is no longer required, okay? Next, when demand would be useless, such as cases when the debtor has rendered it beyond his ability to perform, such as when he outright refuses, no? Demand is useless because the debtor has already said, no, I don't want to comply, no? Or when the thing is lost, no? The debtor cannot be, demand is useless because you cannot demand delivery of a thing which has been lost already, okay? And finally, demand is not necessary in case of reciprocal obligations which involve simultaneous performance, no? Okay? Because default will only begin in that case when one party performs his part and the other has not yet performed his part. Okay? The party in default there is the one who has not yet performed his part of the obligation. Okay? We go to the second kind, which is mora accipiendi, which is delay on the part of the creditor to accept delivery, okay? Or accept performance of the obligation, okay? So, in order for there to be mora accipiendi, first, of course, there must be an offer by the debtor to perform the obligation or prestation exactly as was talked about or agreed upon. Okay? Second, the creditor must have refused performance without just cause. No? Okay? So, what is the remedy here of the debtor? He can simply consign the thing in court. Okay? If you want to learn more about tender and consignation as a special mode of payment, please just watch it in my video on extinguishment of obligations on special forms of payment. Okay? Finally, the last kind of default or delay would be the compensatio morae. Okay? Or its delay on part of both of the parties. Okay? So, what are the effects? No? First, the delay of each party is now cancelled. No? The delay cancels each other out. Second, no? There is no actionable default because, of course, the delay of one party cancels out the delay of the other party. Next, no? The liability of the first infractor, meaning the first one who caused the delay, shall be equally tempered, meaning it may be reduced by the courts. Okay? May only, may. May be reduced by the courts. But if we cannot determine who was the first to violate or first to be in default or delay, then the contract shall be extinguished and each party shall bear their own damages. Okay? Finally, when do the effects of delay cease? Okay, they will cease if the creditor renounces his right or if the obligation has already prescribed. Okay, so that's it for default. Now we can move on to fraud. Okay? Now, fraud is liability for fraud rather is demandable in all kinds of obligations, okay? And there are two kinds of fraud. We have the dolo causante or causal fraud, and we have the dolo incidente, which is the incidental fraud, okay? When we talk about obligations here, no, the fraud that we will be focusing on and which gives rise to a claim for damages is the incidental fraud, dolo incidente. Why? Because when we talk about causal fraud or dolo causante, that is fraud for the inducement to enter into a contract. No, it is present at the perfection of the contract. It is the reason why a party enters into the obligation, okay? And because of that, it is a vice of consent and renders the contract voidable. And the remedy here is annulment. Okay, so this is not what we're talking about here. If you want to learn more about causal fraud and its use as a ground to vitiate consent and annul a contract, please just refer to my video on voidable contracts. Okay? But for our purposes in breach, no, for liability for damages, we talk about dolo incidente or incidental fraud. And what is incidental fraud? It is the conscious and willful evasion of the normal fulfillment of an obligation. Okay? So, it goes into performance. In other words, the contract is already perfected. The consent of the party to enter into the obligation was not affected by any fraudulent words. Okay? The fraud happens in the performance. Okay? And since the fraud happens in the performance, the obligation is necessarily valid, and the remedy here for breach due to fraud is simply an action for damages. Okay? Now, what's an example? Take a look at this difference. This is also my example in the other video, no? But for sake of clarity, let me just give the example again. Let's say part X offers a condo unit for sale to Y and says that you should buy this because it is close to the MRT. If Y or this person agrees to buy that condo unit because of the transportation, then that is dolo causante. That's the reason why they entered into the contract, and the contract is voidable and therefore may be annulled because the consent of this person is vitiated. Okay, so that's not the topic which we are talking about today. What we are talking about is if this person offered the condo for sale and he said that the unit was near public transportation, but this person still bought the unit because of different considerations. They like how it looks, they like the amenities, like that, and they don't care about the public transportation. If it so happens that the unit is not close to public transportation, then the only remedy of the buyer in this case is an action for damages based on breach. Okay? It's not a ground to annul the contract or obligation. Why? Because the obligation is valid. Okay? And the only remedy is an action for damages. Now, one more important thing about fraud, okay? An action for future fraud cannot be waived. And in case it is waived, that will be void. Okay, why? Because waiver of an action for future fraud is void because this is contrary to public policy. It encourages the perpetration of fraud. In other words, the debtor can go do fraudulent acts as much as he wants because he knows that even if he commits fraud, he will not be held liable, no? So that's why a waiver of an action for future fraud is void. However, okay, waiver of an action for past fraud is valid. Why? Because this is simply an act of generosity. Okay? The party who is waiving the action for past fraud is simply saying, oh, what you did before that you fooled me is okay, it's okay with me. I don't care about it anymore. Okay? So that party is merely waiving his right to claim indemnity for the fraud committed upon him. Okay? So finally, we can now move to negligence. Okay? And what is negligence? Negligence is demandable in all obligations, similar to fraud. Okay? In case negligence is present. And what is the definition of negligence? The negligence consists in the omission or failure to observe the diligence required by the nature of the obligation. Okay? It corresponds to the circumstances of the person, time, and place. Okay? Or in other words, this is failure to observe for the protection of the interests of another person that degree of care, precaution, or vigilance which the circumstances justly demand. Okay, whereby the other person suffers injury as a result. Okay? Or, in a word used by my student in Tagalog, it is merely kapabayaan. Okay? You fail to observe the required degree of diligence in performing your acts or in case of omission. Okay? Now, again, I said negligence is demandable in all obligations. And the remedy, if you remember, is damages. Okay? Now, the law gives the court the discretion to fix or regulate the amount of damages awarded to the injured party. And again, the purpose of damages is to simply place the innocent party or the injured party back to the position where he would have been had the obligation been performed exactly according to its terms. Okay? Now, in the definition of negligence, I mentioned it's the failure to observe the required diligence, no? And what is the required diligence? Again, as I mentioned earlier, we follow first the stipulation of the parties, okay, in case they stipulated on a certain degree of diligence. Second, we follow what the law prescribes, okay? The law sometimes prescribes extraordinary diligence or it may be only ordinary diligence, okay? And finally, in the absence of both, we follow the ordinary diligence or the diligence of a good father of a family, okay? Now, we have three kinds of negligence: culpa contractual, culpa aquiliana, and culpa criminal. Okay? Culpa aquiliana and culpa criminal are both directly the source of the obligation. Okay? And in case of aquiliana, these are acts which cause damage to another caused by fault or negligence of the debtor, no? And that negligent act which causes damage is the source of the obligation to pay damages, okay? Provided there is also proximate cause or approximate relation between the negligent act and the damage caused. Culpa criminal, on the other hand, is negligence in performance of an act or failure to perform an act which results in a criminal offense, okay? In which case, the obligation to pay damages will arise from that negligent act or omission. Culpa contractual, on the other hand, okay? Here, negligence is merely incidental because there is a pre-existing contractual relation, okay? So the parties had entered into a contract. In the performance thereof, negligence attends said performance. In that case, damages may be claimed by the injured party, okay? And the final ground for damages in case of breach would be contravention of the tenor of the obligation, which simply refers to any illicit act or defective performance in the fulfillment of an obligation. Okay? So damages may be claimed in this case.